adopted before court on 4th day of May 2023. In the final written address of defendant, 2 issues were formulated for determination. I will read out only the issues. 1, whether having regard to the evidence on record which unequivocally show that the claimant collected all terminal monetary benefits due to him up to 22nd day of October 2018, the termination of contract of employment is not mutual, thereby precluding the claimant from challenging the termination. Whether from totality of the facts and evidence led in this case, the court can safely conclude that the claimant has been able to establish a case against the defendant so as to make him entitled to the relief sought. Defendant has argued same with authorities in support. Registrar, please handle your device over there. It's not from my end here. I hope you are still with me. Sokoto.
Yes, my lord.
Thank you. The claimants, in the claimant's final written address, 2 issues equally were submitted for determination. 1, whether the purported dismissal, termination of employment of claimant conveyed in defendant's letter of dismissal dated 15/10/2018 is valid exercise by the defender of its right or power under the contract of employment to terminate the said employment. 2, subject to the resolution of 1 above, whether claimant is entitled to the relief sought. Equally, counsel has argued same and with authorities in support. I will proceed with the decision of the court. Yes, Sokoto. That's the reason why I said I cannot read the whole judgment entirety, because we cannot be assured of this network. So the defendant the defendant equally filed a reply on points of law, and his arguments are contained here in the judgment with authorities to support same. Now the decision of the court. I read the processes filed by the parties, the evidence adduced with the submissions also made by the respective counsel, and arrived at the following 2 issues for determination. 1, whether the defendant breached the terms and conditions of employment in termination or dismissal of claimant's employment. 2, whether claimant has proved his claims before this court to be entitled to the relief sought. It is not in dispute that the employment relationship in the instant case is that of master-servant. Claimant in the instant case relied on Exhibit CWM2, which is the individual employment contract effective 1st July 2016. Exhibit CWM5, labor terms and conditions, Nigeria, January 2014, which is same as Exhibit G1. And Exhibit CWM6, MSF OCA, Nigeria Mission National Staff Health Policy, January 2014, as what regulates its employment contract. In an employment as in the instant case, where the employee, that is claimant, challenges termination of his employment on grounds of breach of the terms of contract of employment, the only duty of court is to strictly interpret the document that gives right to the contractual relationship and cannot go outside the contract of service as to the terms and conditions. See case of Festus Opeoluwa Daudu and United Bank for Africa PLC, 2004, 9 NWLR Part 878276, and equally Iluabache and Phillips, 2002, 14 NWLR Part 787264. Dismissal of claimant in this case was premised on Exhibit CWM10, dated 15th October 2018, for alleged failure to follow MSF guidelines and protocols. The conduct which defendant termed aggressive and disrespectful, which culminated to the immediate termination of claimant's employment with the defendant. From the oral evidence of the claimant, particularly paragraphs 7, 8, and 9 of amended witness statement on oath dated 6th October 2019, claimant stated that he had expressed his concerns over the health hazards in attending to some critical patients without some basic items like gloves, etc., which were out of stock. That in giving his contrary opinion to that of the medical team leader, he was accused of being disrespectful and not following MSF guidelines in his medical practice. It is evidence of DW1 Muhammad Umar that the claimant was in the habit of being uncouth, disrespectful, and deliberately refuses to follow or obey laid down guidelines and protocols, and expressed his opinion aggressively calculated to embarrass and intimidate the management team. In his evidence under cross-examination, CW1 admitted that his employment was terminated, notwithstanding the heading dismissal in Exhibit CWM10. He also admitted that he received Exhibit CWM10 on 22nd of October 2018, and that he worked for what he was paid for in 2018 as per Exhibit CWM7. If that is what is meant, that he was, as per Exhibit CWM7, if that is what is meant as entitlement in that context, and that the day does not prejudice him as to what he earned for the month, that he collected salary due to him in 2018. When referred to his paragraph 3 of amended reply to statement of defense, filed 6 June 2019, he stated under cross-examination that it was the 2017 National Health Policy of Defendant that was in force at that time, but what he had was the 2014 policy. His oral evidence in chief, it is the oral evidence in chief of DW1 Muhammad Umar that defendant's payroll system factors only 22 working days in a month, and claimant's contract terminated 22nd October 2018, that the number of days not worked as 7, and where this is deducted from 22, it results in 15 working days. That by Exhibit D2, claimant worked for 15 days against 22 days. He stated that Mbagu, that his claimant's conduct was not in the best practice of employee, that there were several complaints against him of instigating colleagues against defendants, which led to his dismissal. He stated that claimant was issued with query, which he responded to, and hearing was conducted, with recommendation made by panel which terminated his employment. That there is no time frame to conclude a matter, and that in claimant's case, it was immediate termination. I read Exhibit CW10 again, which is the letter of dismissal, and CW9, M9, real letter of inquiry. By the content of CWM9, there were communications made by the claimant with officers of defendants, particularly one Dr. Katharina, who referred to by claimant as his direct line manager regarding the matter of ruptures, and that claimant discussed patients severally with his direct line manager and referring to various guidelines in the management of patients. In the same Exhibit CWM9, the claimant drew the attention of Dr. Katharina to a patient in the ITFC who had foul breath, and he suggested the diagnosis, and with concurrence of Dr. Katharina, there was the institution of management in accordance to the ITFC protocol, adapting to the use of what was available in the project. The defendant has not presented anything before the court to show the several queries or instances of warnings served on the claimant regarding the claimant's alleged aggressive or disrespectful conduct. To the defendant's management or line managers. More so by the evidence of DW1 under cross-examination, he admitted that it is the practice in the organization to do a general meeting of staff every morning of Mondays in all locations and departments. And all locations and departments take turns to give updates on successes and challenges being faced. And logistics department gives updates also on constraints of supply units. Constraints of supply to the supply unit. He stated that employees are allowed to state problems also to employers on their grievances. DW1 could not, however, recall exact dates of any complaints against the claimant as alleged. From all the pieces of evidence above, it is my finding that defendant had created an avenue for issues regarding ruptures or challenges faced by doctors as the claimant in this case to be discussed at such Monday meetings. As was done in this case by the claimant, which he communicated also to his direct line manager in Exhibit CWM9. Defendant did not challenge Exhibit CW M9. Sorry, I will read that. Again, claimant counsel, did not challenge Exhibit CWM9 under cross-examination. The defendant counsel did not challenge Exhibit CWM9 under cross-examination of CW1, through whom the document was tendered and admitted in evidence. It is straight law that the best way of challenging the evidence of a witness is by cross-examination instead of controverting evidence by adducing contrary evidence. Thus, oral evidence of defendant cannot contradict, vary, or alter documentary evidence, that is Exhibit CW9, tendered by claimant. See Oweye and Oyinlola, 2012-15 NWLR part 1322, page 84, Court of Appeal. The guiding principle which has been articulated and applied in many cases, including Olatuboso and NISA Council, 1988, 1 NSCC 1025, is that an employer is not bound to give reasons for terminating the appointment of his employee. But where, as in this case, he gives a reason or cause for terminating the appointment, the law imposes a duty to establish the reason to the satisfaction of the court. The defendant in this case has the onus to establish that the claimant was indeed guilty of the alleged misconduct to warrant his dismissal. And where he fails to do so, the dismissal will be wrongful. See Institute of Health, ABU Hospital Management Board, and Kanyip, 2011, LPLR 151 SC, Supreme Court. Defendant in this case has failed to justify the reason for dismissal of claimant via the Exhibit CWM10, and I cannot but hold here that dismissal in this case is wrongful. On the issue of lack of fair hearing alleged by the claimant had admitted in his written statement on oath that he was served with a letter of inquiry on 11th day of October, and that he submitted his reply via Exhibit CWM9, and that the management held a hearing of the inquiry on 18th day of October 2018. It has been severally held by the courts that fair hearing is about opportunity to be heard. And once a court makes a finding that the employee was given ample opportunity to defend himself or herself on the allegations in issue, then such an employee cannot complain of not being given fair hearing. The fair hearing requirement does not insist on oral testimonies, so long as the employee has the opportunity to explain himself or herself by way of query and reply. What is key here is that the exact nature of the infraction or infractions which the employee expected to answer to was made known to the employee. See New Nigerian Bank Limited and GO, Onyovosa, 1995, 9 NWLR Part 419, 327, equally Monike and Unity Bank PLC, 2011 LPLR 1503, Supreme Court. It is premised on the foregoing that I hold that the claimant in this case was accorded fair hearing to the extent that the offenses alleged against him were made known to him and he responded accordingly. Regarding Exhibit CWM10 and the argument of claimant that same dated 15th October, that by Exhibit CWM10 dated 15th October 2018, the defendant had already made up its mind to dismiss him before Exhibit CWM9 was received. The claimant admitted in his evidence under cross-examination that his employment was terminated notwithstanding the heading dismissal in Exhibit CWM10. He also admitted that he received CWM10 on 22nd October 2018 and that he worked for what he was paid for in 2018 as per Exhibit CWM7. If that is what is meant as entitlement in that context, and that the date does not prejudice him as to what he earned for the month, why then is the issue now being raised by claimant regarding the date 15/10/2018 on Exhibit CWM10? In any event, the termination letter in this case cannot operate retrospectively, as rightly submitted by defendant counsel. And I want to agree with defendant counsel in that regard, that termination in this case took effect from the day the claimant received the letter of termination, that is Exhibit CWM10. The court has held in Okoso and CBN 1996, 2 NWLR, Part 428, page 86, as cited also by defendant counsel, that notice of termination of employment takes effect from the date it is served on the employee, particularly where the date stated on the letter has passed. Consequently, I hold that Exhibit CWM 10 of 15th October 2018 cannot operate retrospectively as the claimant's employment was terminated, effective from the date he received the termination letter. I so hold. It is also in evidence, which remain unchallenged, that claimant received his entitlements and was settled via the Exhibit D2. The claimant has not denied this, particularly in his oral evidence and even under cross-examination, that he worked for what he was paid and collected the salaries due to him in 2018. I think particularly in his oral, his evidence under cross-examination. Yes, in his evidence under cross-examination that he worked for what he was paid and collected his salaries due to him in 2018. By Exhibit D2 title settlement, the claimant was paid his entitlements in the sum of 245,965 naira, which document was also signed by him on 24th day of October 2018. And by conduct of claimant, his employment with defendant is taken to have ceased. There is therefore no longer in existence any enforceable contract between the claimant herein and defendant. I so hold. C. Guinness Nigeria Limited and Agoma, 1992, 7 NWLR part 256, page 728 at 742. What then will be the claimant? What then would the claimant be entitled to? The court having held that dismissal in this case was not justified and wrongful. It must not be forgotten that the nature of employment here is master servant, and an order of reinstatement is rarely made by the courts. This is because the court cannot force an employee, even if willing on an unwilling employer. More so, it is now settled that a master can dismiss, retire, or terminate appointment of an employee with or without reasons given, particularly as the employment is not one governed by statute. See Arinze and First Bank of Nigeria Limited, 2004, 12 NWLR, part 888, 663 at 673 to 679. By Exhibit CWM2 and CWM5, Chapter 8.3, Chapter 8.3c, the defendant herein announcing the termination of the contract must give 1 month's notice or salary in lieu of notice. This is also contained in paragraph 7 of Exhibit CWM2 to the effect that either party may terminate the contract after probation period by providing 1 month notice. Defendant has failed to give the claimant the required 1 month notice before termination of employment, and therefore in breach of the contract of employment. See Idufeco and Pfizer Products Limited, 2014, 12 NWLR, part 1420, 96 at 117, paragraphs F to H, and 118 to 119, paragraphs E to C. It is premised on the above reasoning that I find that claimant was entitled, that claimant is entitled, sorry. One month notice in accordance with the terms of employment, and defendant having failed to give him the said notice of termination, he is entitled to be paid his salary of 1 month's salary in lieu of notice. I so hold. Regarding claimant's claims of 50% raise in basic salary and compensation of 25 million, claimant has not presented before this court credible evidence to entitle him to these claims, to earn him the judgment of this court, and I so hold. See CPC and INEC 2011, 18 NWLR, part 1279, 493 at 567, paragraphs D to H. Again, claimant has failed to prove by credible evidence his entitlement to aggravated, punitive, and exemplary damages. More so, court has held, that is the Supreme Court in the case of Thompson and Akinbehi, 2021, 16 NWLR, part 1802, 2A3, 311 to 312, paragraphs G to C, that where a party has been sufficiently compensated for a wrong under one head of claim, it would amount to double compensation to grant an award for the same injury under a different head. I do not find it convenient to grant the claimant the claims on damages, having already granted him payment for salary in the period of notice he ought to have been given by the defendants, as doing so, in my opinion, would amount to double compensation, and I so hold. It has been the law that he who seeks judgment before the court or determination of any right in his favor has the onus of proving by credible evidence his case or the facts in issue. See sections 131 to 133 Evidence Act 2011, as well as case of Indul and Wayo, and others, 2018, 7 SC, parts 111, 164, and 212. A resounding principle of law is that a claimant succeeds on the strength of his case and not on the weakness of defense, as held also in Healthcare Products, Nigeria Limited versus Baza, 2004, 3 NWLR, part 582, at 605 to 606, paragraph H to D. I need to add here that counsel were given the opportunity to join issues regarding Exhibit D2, which they have failed to. And in the circumstance, the court cannot make any pronouncement on same. In all, the case of claimant succeeds in part, and it is ordered as follows. Relief 1 succeeds to the extent that the dismissal of claimant was wrongful, the defendant having failed to justify its reasons for dismissal. Relief 2 partly succeeds to the fact that the letter of dismissal dated 15/10/2018 is accordingly set aside and converted to termination. Reliefs. Reliefs 3, 4, and 5 all fail. The defendant shall pay the claimant 1 month's salary in lieu of notice of termination of his employment in the sum of 243,208 naira only. Cost of action is awarded in the sum of 100,000 naira only in favor of the claimant. Judgment is hereby entered.
Scott, please.
There's a registrar in Sokoto. I think
yes, my lord.
We have just one matter for Sokoto here, which is just the judgment that has been recently delivered. So that will be all for Sokoto so that we can proceed with the Abuja matter. Thank you.
Okay, madam. Thank you.
Abuja cases rather. Thank you.
Okay, ma'am.
The cost, no, the check 100,000. 100,000 the 1 month. Salary of 1 month. Yeah.
Printer ba abin za a printer. Yanzu muna jira ne kawai wancan kira. Wancan za mu sai a samu da.
Cost of 100,000 against the defendant. Okay,